My name is Japo, and my metric number is 2080. I'm gonna represent our case study. And question 1 is Tengku Niaga Berhad, an investing company based in Johor Bahru, had appointed Sarah as the sole auditor. In discharging one of her main duty as an auditor, Sarah completed audit on the company financial statement for the current financial year. Here, auditing report will be presented in the coming annual general meeting. However, 3 are some issues. Those where Sarah had negligently prepared her audit without adhering the right legal framework, unknown to her Salim, an investor who had suffered heavy losses as a result of his rebellion on Sarah audited account to initiate a legal proceeding against her. In the meantime, Sarah had also provided her good advice for the company to extend the credit to extra holding. After being satisfied this was the period to do based on their current financial and position at the time. Unknown to her and appreciated worldwide pandemic takes place shortly after NL as the holding unable to settle the debts. According to the contract entered, Tengku Niaga Berhad blamed Sarah and now intends to sue for the losses suffered. As their plan, Sarah had breached her duty by frauding wrongful advice. The issue whether Sarah can be sued or removed by the company. The general rule of this section, according to section 266 subsection 1 Company Act 2016, every auditor of company shall report to the members on the financial statement, and the company entertain another record relating to those financial statements. It is being holding company for which consolidated financial statements are prepared shall also report to the members consolidated financial statements, and the report shall be A. in the case of public company laid before the ex company, B. in the case of company escalated to its member, or and 3. laid before the company at a meeting of the members. According to section 276 subsection 1 Company Act 2016, the member of company may remove an auditor from officer at any time by ordinary session at the meeting in accordance with section 277. This session shall be taken as briefing to person removed or the competition or damage payable to him or her in respect of termination of his appointment as an auditor. An auditor not removed for office before the expiration of his term of office except by resolution under this section. Okay, related case to these cases is like Caparo Industry PLC versus the 1990 facts. Caparo, a small investor, purchased shares in company relying on the account prepared by Dickman. Caparo lost money due to the account being neatly prepared. The issue is, could Dickman be liable to Caparo for the negligent preparation of relief upon company accounts? Given there was no contribution relationship between the two parties' decision, it was decided that there was promiscuity between the parties and the responsibility of loss and damage. The Caparo takes responsibility for semi and fair just as receivable thus fell due to lack of promiscuity. Application. In applying to section 2771 Company Act, a special notice for social notice shall be required for decision to remove an auditor from office at the general meeting of company. Then the auditor may be removed the general meeting by a resolution passed by a majority votes more than 50% of members. Another person can be appointed as an auditor at the same time. The company is required to give a notice in writing or removal the registrar within 14 days, after the removal, in which the registrar will appoint an auditor in the company did not appoint a new auditor, and the auditor cannot be removed by the director. The conclusion of situation, based on the situation, the company no need to sue Sarah, but the company can remove Sarah from being the company auditor after section 277 subsection 1 Company Act 2016. That's all for me. Thank you.
Assalamualaikum Sewasfi. My name is Muhammad Firdaus bin Anwar. My metric number is 20D80 22F 1035. I will be the second presenter. In question 2, I will explain an answer for the first issue. For the first issue is whether Azlan has a strong basis to challenge his termination and seek appropriate remedies. For law definition for auditor is an auditor is independent professional authorities to inspect and examine and verify the accuracy of business record to ensure true and fair of past financial performance and current financial position. Next one, I will go to the general rule of auditor. Under section 276 section 1 subsection 1 and subsection 1A 4 of Companies Act 2016, resolution of remove auditor from office. The member of a company may remove an auditor from office at any time. Section 1 by ordinary resolution a general meeting. For the exception, section 277 subsection 3 of Company Act 2016, special notice required for resolution to remove auditor from office. The auditor may make a representation in writing not exceeding a reasonable lag to the company within 7 days from the receipt of the special notice, and may request prior to the meeting at which the resolution is to be considered. A copy of the representation be circulated by the company to every member of the company to whom notice of the meeting is sent. Section 284 subsection A of Companies Act 2016, duty to inform upon cessation of office. A company submit a copy of the written representation of his statement of submit a copy of the written representation of his statement of circumstance connected with his resignation to the registrar. For the related case, for this case is RE company number 007946 of 1993, ex parte Smith 1994. Issue for this case is whether an auditor has strong basis to challenge his termination. Fact: in this case, an auditor sought judicial review after being removed from his position without following proper procedure. He claimed that the company did not allow him a fair or an opportunity to respond to the allegation. Held, the court found that the majority shareholder has conducted the affairs of the company in a manner that was unfairly prejudicial to the interests of the mandatory shareholder. This typically involves actions that are contrary to the understanding on which the monetary invested or that harm their legitimate exception application. In applying, according to Section 277, Subsection 3 of Company Act 2016, special notice required for resolution to remove auditor from office. Auditor was given the opportunity to defend himself or herself against the termination. Next, upon receive the special note, the auditor concerned may within 7 days from the receipt of the notice make a representation in writing to the company and request that a copy of the representation to be circulated by the company to every member to whom the notice of the meeting is sent. The auditor then shall submit a notification under Section 284 cessation of office by Auditor Companies Act 2016 to registrar within 7 days from the submission of the written representation. For the conclusion, therefore, based on the situation, by leveraging the principle established in this case and the statutory requirements under the Companies Act 2016, Azlan has a strong basis to challenge this termination and seek appropriate remedies. I will pass to the last presenter. Sorry. Thank you.
Hi, my name is Brenda Namana and my matrix number is 20DAT22F2002. And the question is, at the same time, Bosco Sunian Berhad had defaulted the submission of annual return by logging the document 2 months later than the company anniversary in January, without knowing the consequences of such breach as was found in his was the company third consecutive breach of the Section 68 of the Companies Act 2016 since 2021. If you are appointed as an interim auditor for the said company, what would be your advice on the content, requirement, and principle with regard of the annual return? So the issue is whether Bosco Senior Berhad had rapidly breached Section 68 of the Companies Act 2016 by submitting its annual return 2 months late for the third consecutive year since 2021. And the law for this situation is definition. An annual return is a basic information of a company. Section 68 subsection 1 of Companies Act 2016, duty to lodge annual return. Subsection 1, a company shall lodge with the registrar an annual return for each calendar year not later than 30 days for the anniversary of its incorporation date. General rule is Section 576 subsection 1 of Companies Act 2016, annual return. A foreign company shall lodge with the registrar once in every calendar year an annual return in the form and manners of the registrar may determine. Related case is Case Securities Commission Malaysia against Hong Song Construction, Senior Berhad and Annual 2019. Issue: whether the company failed to submit its annual return within a stipulated time frame. And in fact, in this case, Hong Song Construction, Senior Berhad failed to comply with the statutory requirement of submitting annual return and financial statement over multiple year. The Securities Commission Malaysia initiated legal action against the company for non-compliance, emphasizing importance time submission and the consequences of failing made regular obligation. Law. Held. The court found that majority shareholder had conducted the affair of the company in manner that was unfairly prejudicial to the interests of the minority stakeholder. This typically involves actions that are contrary, understanding of which minority invests that harm their legitimate expectation. Application. In applying, the company has legal obligation to submit its annual return within the specified time frame to avoid penalties. Next, by repeating breach of Section 68 can result in fine, potential disqualification of the director and damage to the company reputation. Besides, Bosco Senior Berhad should establish robust internal control and procedure to ensure timely submission of future annual return, including setting up reminder and checkpoint throughout the year. Moreover, the company can establish a system reminder and alert to ensure that deadlines are met. So this could be invoice setting to digital reminder well in advance due to that. So conclusion is, based on situation, it is imperative to advise both consumer hard on the importance of adhering to the submission deadline of the annual return and implementing measures to ensure compliance with Section 68 of the Company Act 2016. Failure to do that can have serious consequences for the company's financial and legal standing. So that's all from me. Thank you so much.